account. Just to be clear, you didn't do it.
We know who did it, Steve. We know. And we know who spearheaded this cover-up. You all know.
Yes, we do.
If John was beaten up and attacked in that house, who did it?
We don't know.
We don't know.
We don't know. And it's not for us to know. Somebody other than Karen is responsible for that, for the killing of John.
Yeah. Roberta in the truth zone, mic hitting raw. Spotlight shining, she exposing the flaw. Debunking the myth, breaking their facade. This is Glass City, respect the squad. On these NYC blocks where the skyline flex big. Roberta Glass slicing lies with a truth rig. Innocence frosters, your stories unravel. She's a map through the madness of gritty gravel. Glass don't bend and facts don't break. She's a storm that's called, you feel the quake. Exposing tales stitched with crooked seams. Justice in the lens, shattered fake dreams. Screams about killers, painted heroes in disguise. She burning propaganda with fire in her eyes. No glamour for the guilty, she call it straight. She backs victims, the voice stay awake. Stats and receipts, no spin, no clutter. Cold cases whisper, she cuts through the mutter. Truth's her tempo, don't confuse the beat. She's standing for the real while you taking a seat. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time to play. She's glass hard, break the false and save the day. True crime's a block, facts the artillery. Spinning those lies, yo, she checks that misery. Tabloid tales get smashed, no time.
Okay, how is everybody? Hello, Maestro. Thank you so much for moderating. The hardest working moderator in the live streaming business. Hello, Knowles fan. Hey, Jude, Sandy, Allie, Anna. Well, it's big news, breaking news, breaking news. Karen Reed, in another stunning reversal, now knows who did it. And in fact, is it the Loch Ness Monster? Is it Bigfoot? Is it the guy that sleeps under your bed and scares you at night? The answer is almost as ridiculous, with just as much proof as all of those three I just mentioned. She's blaming a contingent of the Alberts. Now, we heard about this in a motion. I was very disturbed, as Judge Cannone had just given her lay down the law speech as she sanctioned the defense with a supposed to be stunning. It really was a very, with a pretty harsh admonishment that how dare that she will take no more stretching of the truth, every euphemism for lying to the court. She mentioned misstatements, no more misstatements, no more lack of candor. How many euphemisms for lying? I think she hit every single euphemism for lying there. But they went on in that same hearing to stretch the truth, have a lack of candor, i.e. lie to the court, in my opinion, my view of it. But one of the things that I found so infuriating was that they brought up this third-party culprit. They were trying to keep out Jennifer McCabe, anyone who testifies as a witness in the case, for closing arguments, because one juror, unidentified juror or person, I don't even know if we know for sure it was a juror, told Vanity Fair that they were intimidated by the Alberts' appearance next to supporting the O'Keeffes, sitting next to them in court. So the defense said, well, they're referred to them as third-party culprits. And I found this rather shocking because they had never developed a third-party culprit in their entire defense. Now, Judge Cannone had left the door open to argue third-party culprit, meaning someone else did it, and this is who. We have a story of who did it. Someone had the means, mode, and opportunity to do the crime, and they've cut that down. Means, motive, opportunity. They've cut that down to anyone who was near in the proximity of John O'Keefe and Karen Reed that night. And they really have nothing. I mean, what I've gotten from these hearings, these last hearings, is how little they have. Now, if they think they're going to win on defense experts, possibly. I mean, the best thing I thought they had was ARCA. And if you caught my live today of the hearing, Hank Brennan, a lawyer, worked with Hank Brennan, Whitey Bulger case, saying that Hank Brennan is the best cross-examiner he's ever seen, or one of the best. Now, if they're cross-examined, ARCA, and I'm curious if Hank Brennan can bring in their testimony from the last trial. Last trial time you told the jury that you were unpaid. What's this? I can't believe they're being invited in to lie to the jury again. I mean, it really seems like Judge Cannone is another wing of the defense. That's how I view her. And I have really, I'm not someone who picks on judges. I'm not a lawyer, but even I, struggle understanding the logic of a lot of her decisions in this case. It makes no sense to invite back a team that two witnesses, expert defense witnesses, I'm talking about the ARCA witnesses, who were originally hired by Karen Reed and the for this grand jury investigation which was started by Karen Reed and David Yannetti, and for what reasons and why the Attorney General's office went with it, it's still a mystery to the public. It hasn't been released to the public. But these ARCA witnesses get people, usually are involved in civil trials, and they do these, basically, it looked like to me like these crazy physics, experiments, like involving cannons and stuff. And they determined that the damage to Karen Reed's vehicle could not have been done by running into John O'Keefe with her vehicle. Congratulations to them. They looked shady when they testified. For one thing, all their material that they used was handpicked by the defense. Another thing, and what I mean shady is from a skeptical eye. If you're not looking skeptically, they look great. They look like polished. They keep guys who keep referring to the science, respectable. If you've been around the block and watched a few trials and know what expert witnesses are hired for, it gets less impressive. But I thought Adam Lally did a good job with his cross. Like, if you had more information, would that change your view? Oh, no, we had all the information we need. And that's odd for a man of science to say that. Look, we don't need anything else. We're going to cap it off right with this cherry-picked information given to us by the defense. So anyway, even my cat is upset. Did you guys hear that? Even my cat is upset hearing about ARCA. You have anything more to say, Kitty, about ARCA? No, he's going to take a nap. It gave him such a headache hearing about it. He's going to his kitty bed and he's going to take a nap for the rest of this show. All right. So today I thought we had the most fascinating argument, which was, did Karen Reed waive her right to attorney-client privilege after she ran into John O'Keefe in a rather large SUV, smashed her taillight to smithereens, going 24 miles an hour in reverse, her foot 75% down on the pedal, never once touching the brake. When she called him in disgust and asked him, according to her, could I have done it? And we'll hear the clip in a second. Did that waive her right to the privilege of that conversation? Brennan was asking Yannetti to testify. He was asking for the contents of those communications. And she talked about it not only to, I believe, Vanity. Am I right with, I want to say, I want to say Vanity Fair, Ted Daniels. I may be wrong, but it's definitely this ID Discovery pick. And now I had this cold yesterday. Now I'm forgetting. If you guys know, she gave it up at least twice. She talked about this conversation. Is it the Ted Daniels interview where she's driving the car, or is it Vanity Fair? Let me know. I'll watch the comments. So here, let's listen to the way Christina Rex reported on it. There's a little editing out. The ID Discovery documentary is very protective of their copyright. So without an okay from them and without being WBZ, I'm just going to, I edited over pictures where they used actual pictures from the film from the documentary, but you can hear Karen Read. Let's take a listen.
Here's a big question. Can Karen Read's text messages to her lawyers be used against her at her retrial? That question goes before a judge tomorrow. WBZ's Christina Rex spoke with our legal analyst today to show us why the request is so unusual and what it tells us about the case, even if that request is denied.
It's so rare that something like this would ever be requested.
Prosecutors want access to messages between Karen Read and her lawyer, David Yannetti, from the days following John O'Keefe's death.
Most of us who are, whether you're in the legal world or not, believe that the sanctity of attorney-client privilege should remain that way.
But prosecutors claim that privilege is gone, writing in their motion, quote, the communication.
That was just my own joke edited in there. Okay. That was my own footage of Karen Read and Alan Jackson's canoodling moment. That Karen Read supporters still think that's CGI'd or edited in some computer generated in some way. It's amazing what they would believe. And I think it really supports my theory that if there was a witness or an actual video of Karen Read doing this crime, her supporters would say that it was police generated, computer generated.
Are no longer privileged nor confidential because the defendant chose to widely and publicly disseminate them.
David Yannetti is the first and only call I made.
This clip is from a documentary released last week, and prosecutors say Karen Read's own statements should get them access to her texts, specifically this line.
And then when I hired David Yannetti, I asked him those questions the night of January 29th. Like, David, what if, I don't know, what if I ran his foot over? Or what if I clipped him in the knee and he passed out or went to care for himself and he threw up or passed out? And David said, yeah, then you have some element of culpability.
WBZ legal analyst Catherine Loftus doesn't believe the motion will be granted, but says it sheds light on prosecutors' strategy for trial number 2.
I think it shows us that he's going to use everything she says against her, which is the reason that you're advised, when you're arrested, that anything you say can and will be used against you.
Right. So I thought similarly. Hank Brennan has gone after every interview, every statement. As soon as the ID Discovery TV show was put out, Hank Brennan was filing motions with quotes with it in it. Karen Reed's statements, I've always felt, now, along with her car data, are some of the strongest evidence against her. I mean, there's so much evidence against Karen Reed. I mean, to me, it seems like, and I'm going to answer some of the Free Karen readers who've left messages all over my channel, on my interview with Julie Grant on Court TV, in my videos section, in my live streams. I mean, the police are so corrupt. What about the butt dials? What about okay, not everybody tells the whole truth on the stand, but it doesn't mean they're culpable. Right? Sometimes they're protecting things that are just personal, that they don't want broadcast worldwide in a high publicity trial. Sometimes when alcohol is involved, things get sloppy and butt dials happen. But there's nothing like pieces of Jen McCabe's taillight embedded in John O'Keefe's shirt. There's nothing like the shifting stories from, we all know who did it, to we don't know who did it. Oh, we know who did it again. I mean, not one Free Karen reader raises an eyebrow. It's like, well, last week they were telling us we were not detectives. We don't know who did it. And this week they're telling us they know who did it, and these are third-party culprits. And they're going to argue both a Bowden defense, meaning it's a sloppy police work. These are the refrains of innocence fraud campaigns everywhere. Tunnel vision investigation, sloppy police work. And they're going to argue that. And a shifting real killer or killers. Those are some key ingredients in innocence fraud campaigns every time, always. So they're going to argue that it was both a sloppy police work, which is a very compelling argument, especially in this country. I don't know what makes this such a compelling argument, but here's Alan Jackson or David Yannetti's going to close on something like, well, if you don't want to bet your life on this police investigation with solo cups, which, never mind, were a very inventive way to preserve evidence during a nor'easter, but never mind that. Which is interesting because I can see the solo cups being more important had they been contaminated with, DNA. I mean, it's John O'Keefe's blood. I mean, I think everybody agrees that it's no one but John O'Keefe's blood. So what does it matter what it was transported in? If this were a key DNA issue where it was contaminated by these solo cups or something like that, but there's not an issue with whose blood it is. So why does it matter? And what does it matter that it was transported in a shopping bag? If it was transported in an FBI bag, would it make it any more reliable to everyone? I mean, so he's going to say to the jury, if you can't bet your life, if you wouldn't bet your life, they love to say life. It's not her life. It's her lifestyle, really. If she gets convicted, she's going to prison. She still has her life. John O'Keefe doesn't. If you wouldn't bet your life on this police investigation, don't bet Karen Reed's life on it. And it's a famous argument by defense attorneys everywhere. And it's very compelling, and it seems to work well with American audiences. However, at the same time, they're going to argue that someone else did it, and the police were too stupid to see that zero evidence, nothing pointed to the Alberts or Jen McCabe. But wow, weren't the police terrible for not giving them the full rundown? And of course, I think that the most important statement that Karen Reed made, at least the one that I found would find most convincing if I were a juror, and think I would never be a juror in this case, of course. But Karen Reed's saying either I'm going down or Jen McCabe's going down. And if Aidan Carney takes the witness stand and we have this witness harassment campaign coming in, I think jurors are going to hate her. So we haven't really gotten a lot of rulings on some of the most important stuff, or some of the things I find most fascinating about this case. But today I was disappointed because I did feel like she waived it. However, I was talking to my boyfriend, and he's like, look, lawyer-client communications in this country, I mean, that's really the bedrock foundation of our legal system, that you can tell that everything that you tell a lawyer is private. But is it, once you go to a zillion, many different news outlets and discuss it, is it private then? Judge Cannone didn't even finish listening to the arguments and decided. So she thinks there would be no rebuttal by Hank Brennan that would be strong enough to convince her to approve that.
I think a lot of people often think that means just in whether it's a police interrogation or whether it's relative to law enforcement. It's not. It's whether you say it to your neighbor, whether you say it to a reporter.
There is a hearing here at the courthouse at 11 a.m. on Tuesday, and there's still a lot of pretrial work to.
Right. So they say, we often hear what Catherine Loftus is saying is, we often think, don't talk to the police. But once you talk to the media about it, it's no longer privileged. I think another judge, I don't know. It would be curious to know. Certainly no judge in Massachusetts is going to okay that. But maybe a judge in a more conservative judge. I don't know. Let me know what you think. Curious to know. Also, everybody's talking about the communications between David Yannetti and Karen Reed on the 29th. But how about Jack Diamond? Does anybody know the name Jack Diamond? Does that ring a bell for anyone? That's the first lawyer she talked to when she in the car on her way to Denton, where her parents live. She's Googling DUI lawyers. This is Innocence Fraud Watch's blog. Killer Karen Reed retrial. Murderer and con artists. Cell phone extraction timeline included. Elizabeth Little's. This is when Elizabeth Little mentioned Jack Diamond in her July 2023 email. At around 1:19 p.m., while in her SUV with her father, William Reed, who was driving to his house in Denton, Karen Reed received a call from then State Trooper Michael Proctor's private cell phone. Then at around 1:27, while still in her SUV with her father, Karen Reed carried out a Google search for DUI attorneys. Karen Reed and her father, William Reed, arrived in the driveway of 345 Country Hill Drive in Denton at around 2:12 and 15 seconds p.m. As soon as they pulled up, the pair of them got out of Karen Reed's SUV and ran to inspect her smashed to smithereens right rear taillight. On October 29, 2024, Vanity Fair published a story by innocence fraudster and gaslighter Julie Miller, headed Karen Reed Tells Her Story, Part 1, a murder trial in Massachusetts. Julie Miller stated, in part, when they got home, Bill Reed searched criminal defense attorneys in Boston. David Yannetti's name appeared. David Yannetti's name and picture popped up. Bill's vetting was more on instinct. A devout Catholic who prays every day. Oh, is this the biggest love letter piece to Karen Read? Her father, who may be up for sainthood in the Catholic Church because he goes to church every day and prays. A devout Catholic who prays every day, Bill Read we're talking about here, and paid his way through college. Oh, when is his sainthood? Paid his way through college by working as a night guard in Fall River. Bill Read decided on Yannetti because he looked like an honest man, unquote. What do you think? What do you think? I've always thought that William Read was very much like Karen Read, a criminal by practice and at heart. I mean, that's, just like a criminal mind. I don't know how much criminal activity. I'm not accusing him of a criminal activity, just having a criminal mind, certainly. And if he said he looked like an honest man, I would say he looked like a fraudster. That's the lawyer I want for my daughter. That's how I interpret it. Let me know what you think. In the Commonwealth's March 20th, 2025, Commonwealth's motion to compel communication between the defendant and attorney Yannetti stored within the defendant's cell phone data, Special Prosecutor Hank Brennan quoted statements made by Karen Read to Gretchen Voss regarding January 29, 2022 as follows. Gretchen Voss, you never said, did I hit him? I hit him. Karen Read says, I said, could I, did I, could I? Sounds like a song, doesn't it? I said, could I, did I, could I, did I hit him? Doesn't it? Listen to the rhythm of this. I said, could I, did I, could I, did I hit him? And then, when I talked to David, now this is later, David said, Karen, if you incapacitated him in any way, there is culpability there. And I thought, all right, maybe this is what, maybe I said to my mother, just go forward a second. They were asking me what it was like. Did they come out? What was the house like? David Yannetti faxed a letter to the district attorney's office about Karen Read and stated of the letter, as I put in the letter, and I'd like to again have this marked as an exhibit for the bail hearing. As I put in the letter, the police multiple times violated her right to counsel multiple times, Your Honor. And well, we'll be able to show that at a motion to suppress hearing. They've never been able to show that, not once. Again, is David Yannetti, let's use Judge Cannone's words, misrepresenting things to the court? Another court, yet again, sure looks like it. February 2nd, 2022, during Karen Read's February 2nd, 2022 arraignment hearing, David Yannetti referred to a letter he faxed to the Norfolk District Attorney's Office on Saturday, the 29th. And she hired an attorney almost right away. And by the way, there will be substantial issues regarding a motion to suppress statements here. Below are extracts from the community's proposed procedural regarding communication stored on cell phones for examination of iPhone, pursuant to a search warrant issued on February 2nd, 2022. On February 2nd, the Massachusetts State Police applied for and received a search warrant to examine the contents of the defendant's iPhone. Trooper Nicholas Garino, a certified electronic forensic examiner, then attached the device to a decryption machine software to access said data from within the cellular phone. The decryption machine software eventually allowed access to to the data within the device, and Trooper Carino completed an extraction report containing the data. On August 11th, former Trooper Michael Proctor began to go through Karen Reed's iPhone, this iPhone extraction. However, he was not able to complete his search of the phone because he came across privileged messages between Karen Reed and her attorney. And so on May 3rd, the extraction began. June 15, 2023. On June 15, 2023, Christopher Kelly, director of the Digital Evidence Laboratory, contacted defense counsel and alerted him that initial privileged filtration procedure was complete and forensic examiner was prepared to provide the defendant with the data for review. So July 18, 2023 is when Karen Reed's lawyer, Elizabeth Little, emailed prosecutors Adam Lally and Laura McLaughlin, as well as defense attorney Alan Jackson, David Yannetti, and Ian Henshey, never to be seen again. MIA, Ian Henshey. Her emails were also sent to Gilbert Saucedo. This is interesting too, that Gilbert Saucedo thing. Maybe in another live stream I'll talk about him. He has some contacts with justice organizations, very much ideologically aligned with the Innocence Project. Elizabeth Little's email was in relation to Reed's privileged filtration discovery requests and stated in part, I've identified 2 text messages which were exchanged between our client and another defense attorney, Jack Diamond, not Mr. Yannetti, in furtherance of representation which are privileged. I can file a formal privilege log with the court as early as tomorrow, unless you would prefer that I reach out to the Attorney General's office directly to expedite this issue and have them redact these 2 messages now. You know what comes to mind is how quickly Karen Reed blamed alcohol, was like, I need a DUI lawyer. This isn't she must be really angry with the Commonwealth that they sussed out that this wasn't the product, just the product of drinking. When she got that second degree, you can see her having a fit getting arrested in the ID Discovery TV show, disgustingly titled A Body in the Snow. She refuses to move her arm around the back of her to get handcuffed with Proctor. Proctor eventually says to another police officer, did you see how crazy she is? Something to that effect. And I think that's how Proctor became the target of her harassment campaign. But I don't think she ever thought that the state or the Commonwealth was smart enough to suss out that this wasn't a drunken accident. And when they figured out, putting the evidence together, that looking at Karen Reed's communications, Karen Reed had done everything to mix it all up, create confusion and distraction. And on the morning of the 29th, I don't think she thought she would have just like a small DUI case for her murder of John O'Keefe. And boy, when she found out that they figured it out and she was being charged with murder too, she really gets quite angry. And then she starts to get even by creating a witness harassment campaign with the help of her lawyers and Aidan Carney, and a campaign against the O'Keefe family and John O'Keefe, in my opinion. So the Commonwealth was restrained from reviewing the defendant's cell phone data for 18 months. So on July 21st, 2023, this is very similar to what we've seen with the defense hiding discovery from the Commonwealth. They had not received a redacted version of the extraction report of Karen Reed's phone. The defendant had had access to the entirety of her cell phone data since March 2023. As of July 21st, 2023, the Commonwealth has yet to access any information or evidence. So put the Commonwealth on the back foot, sandbag them at trial, have them move very quickly. Don't give them a lot of time with the evidence. That has all been techniques of the Karen Reed defense team. So below are extracts from Commonwealth's motion to compel communication. So no to the communication from the phone. Karen Reed told me there was a rumor, this is what she told Vanity Fair, that there were texts between her and her lawyer in which she implicates herself, texts that police supposedly read when they confiscated her phone, but that will never be released because they're privileged. Here's my question, and this is a question asked of me, and I don't know the answer to it. Can Trooper Proctor, if he saw incriminating texts, talk about them now that he's no longer a police officer? If he by accident saw something, can he testify to it now that he's been discharged? Proctor, the state trooper himself, referenced an exchange on the stand saying that he stopped looking through her phone when he saw messages between Reed and an attorney. But Reed and Yannetti each point out that they didn't communicate until after Massachusetts State Police has seized her phone and car. I didn't even have a cell phone number for David until around several hours after Proctor left with my phone. I never texted him on January 29th. Proctor testified on the witness stand that he saw text between David and me as a provable lie. So are these text messages between Karen Reed and Jack Diamond? Let me know what you think. And there's Michael Proctor's. So will Jack Diamond come into it? Curious what everyone thinks. Hey, Laxadaisical. Thanks for the super sticker. I'm going to take a break, short break. And when we get back, what to expect at trial and go through the hearing. Don't go anywhere. I'll be right back.
Mic check, Roberta strides through the static haze. True crime Gotham where the shadows play their plays. Fraudsters fold when a spotlight beams. Fact-focused queen busting propaganda schemes. Glass shatter lies echoes through the streets. Standing for victims, giving voice their beats. NYC Post, truth sharp as night. Roberta exposing she's the anti-fraud light. Hard cash warrior, dissecting state and defense. Twisted innocence, claims breaking pretense. Gotham's truth seeker cuts clean with the blade. Facts in the forefront, no justice gets swayed. Cold facts drip heavy, real talk unfurls. Cracking cases open like oysters with pearls. Innocence gimmicks crumble to dust in the wind. For victims, her creed, justice till the end. Headphones blazing, she drops heavy artillery. Narratives twisted, meet blunt object civility. Roberta got receipts that unravel the ploy, exposing the lies these fraudsters deploy. Glass shatters lies, echoes through the streets, standing for victims, giving voice their beats. NYC Pulse, true sharp as night. Roberta exposing she's the anti-fraud light.
Okay, back to today's hearing. It was rather subdued. There's only one time where Alessi, I think, accused Hank Brennan of using, I don't know, these are my words, not his, sort of dramatic language. But again, Hank Brennan seems frustrated with the discovery handed over by the defense in this case. This is the way and of course they have something like 245 jurors, something like that I heard coming. Let's look at the way that WBZ is reporting on the trial, upcoming trial that starts next Tuesday. Of course, we're not going to see any of the voir dire with the jury, the picking of the jury. There was a curious part of the hearing, was it today, where Alan Jack said, once Karen Reed, he knows, I had to laugh, he knows his client is pretty scary up close. He's like, can we just have an earpiece in Karen Reed's ear so she can listen in to the sidebar voir dire of the jury? We don't want to scare her with her crazy eyes and her feral gnashing of the teeth and snapping of the jaw when she gets angry at potential jurors. Can we just have her sit down here at the table with an earpiece in her ear listening in? Does she have to be within touching distance of any of these jurors, Your Honor? Oh. Thanks, Lackadaisical, for gifting 5. I really have to do something. Lackadaisical, with all these memberships you're gifting, I have to do a members only show soon. My understanding is that they'll be given out at random. Maybe next week? What do you guys think? Maybe next week when they're picking jurors and things are slow, maybe we'll do just like I don't know. Let me know what you think. Or if there's something you'd like me to talk about, particularly in a members only show. I have so much on the agenda. I knew I wouldn't get to all of it today. But let's look at the way WBZ is reporting on this retrial.
This is complete. I'm declaring a mistrial in this case.
At that moment on the 1st of July, 2024, you could hear a pin drop inside the Dedham, Massachusetts courtroom. After nearly 5 days of deliberating, the jury in the Karen Reed murder trial could not reach a unanimous verdict. Outside the courthouse, cheers erupted from dozens of supporters wearing pink who had been standing along the sidewalk for weeks.
We are accepting the hung jury.
If this is retried, will you be here?
I will 100% be here.
I mean, this is so embarrassing, isn't it? So embarrassing. 1 minute. Isn't this crazy? 200 feet. And that's something that we haven't heard about, is the buffer zone. I think it should be like the town over. I mean, the fact that the jury could hear the Free Karen readers in court is absurd. This is why I say Judge Cannone is like another wing of the defense. That's just one small reason and a giant list of reasons.
I hit him! I hit him! The number of people in blue supporting victim John O'Keefe and his family also grew during the first trial.
Most normal people don't show up and tailgate at a murder trial, and we're here to support the O'Keefes. They have been harassed relentlessly.
The case has garnered national attention.
It's smoke and mirrors, and it's going through my private life and trying to contrive a motive that was never there.
Right. I might actually agree a little bit with Karen Reed there. I go back to my last live episode where I explain in detail why I don't feel that jealousy is a motive for Karen Reed. So maybe I would agree with her, but as far as going through her private life, isn't that rich coming from Karen Reed, who started a federal investigation just so she could, and is the Facebook queen of going through people's private Facebook and gathering data on them to paint an unflattering portrait and embarrass them and make connections and accuse them of being the real killers. It's rich that she says her privacy has been invaded when she's invaded everyone else's.
Failed miserably, and they'll continue to fail. No matter how long it takes, no matter how long they keep trying, we will not stop fighting.
Karen Reed and her defense team spoke on the steps of the courthouse.
Wouldn't that have been funny if Alan Jackson just had like a odd moment there of really telling the truth? We will not stop fighting. We will not stop our con. fighting. Looks like.
Moments after the judge declared a mistrial, minutes later, the district attorney's office decided to retry the Bristol County woman for the death of her Boston police officer boyfriend, John O'Keefe. The second trial is set to begin April 1st, with the second-degree murder charge still on the table, despite a...
Yeah, I'm with you, Shivani. Motive often shows on her face vengeance. Yeah, it was to teach him a lesson. How dare you, John O'Keefe? Leave me. And all this stuff about accusing him of sleeping with someone else. And it's always just to point the finger elsewhere, get people in a fear state of mind, a confused state of mind, get the heat off of her and onto them. Accuse, very much like a Scientologist. Never defend, always attack. That's what L. Ron Hubbard said, who created Scientology. Terrorize, attack, belittle.
Federal appeal from her defense team. But what led up to a mistrial, and what's happened since? A lot. Let's take a look back at some of the first witnesses to take the stand.
I hit him. Oh my God, I hit him.
Experts say testimony of the first responders the morning O'Keefe was found outside of 34 Fairview Road in Canton is some of the most compelling evidence in the case. Reed is accused of backing in.
So this is called What to Know Ahead of Karen Reed's retrial. So they're recapping some, and I just thought we'd look skeptically at how the media is reporting on her trial. This is WBZ in Boston.
To him with her SUV and leaving him to die during a snowstorm in 2022. Her attorneys claim she was framed and say the Boston police officer was beaten up at a party inside the Fairview Road home.
John never came into my house that night. He would have been welcomed, and the defendant would have been welcomed with open arms.
Reed's defense also claims the Albert's German Shepherd dog Chloe could be involved. But prosecution witnesses say no dog DNA.
Yeah, I mean, the Commonwealth has the momentum now going into trial. ARCA was a huge loss for Karen Reed. Look at her other witnesses. Now, she's adding witnesses. I don't know. One is an ex-FBI. That I know that's something I've talked about a lot on my channel. What I consider as innocence fraudster FBI agents like Steve Moore, Jim Clemente, who jump on an innocence fraud campaign. Jim Clemente and Steve Moore both told wild inaccuracies. How about that? I'll use some Judge Cannone words, i.e. lies about Amanda Knox, the facts in Amanda Knox case, consistently. Also, Jim Clemente, I believe he jumped aboard a little bit the West Memphis 3 and Adnan Syed's innocence fraud campaign. He also was hired by the Paterno family to absolve Paterno of any knowledge of Sandusky's behavior. And right after Jim Clemente released his report absolving, which was on a website, absolving Paterno of any knowledge of Sandusky's predatory behavior, the New York Times released a story that Paterno had been notified of Sandusky's behavior, had gotten complaints about it as early as 1976. So despite who they attaching themselves to the bandwagon of so many innocence frauds campaigns, they still managed to sway a lot of people's minds in the true crime community and outside of it. People think, well, oh, the FBI has such a good name, but they are ex-FBI. No one asks why no one really can look into why they're ex-FBI and no longer working there. So it's also, all these kind of experts are used in these innocence fraud campaigns, coroners or medical examiners, people with degrees they like to use, right? Who have impressive titles or had impressive titles. Let's put it that way. It's really an appeal to authority that you shouldn't fall for. You should make sure that you're getting all the evidence. Go to the court transcripts. It's the most unbiased, most exhaustive place for facts about a case there is. It's the court transcripts or the case filings, the moving papers if it's pretrial. This is such a rare case. Usually the cases I'm talking about, they have been litigated, post-litigation. I mean, they had been tried 10, 20 years before activists and lawyers try to, and podcasters and documentarians, quote unquote, try to undo their convictions with claims of innocence. This is so unusual because it's coming pre-trial. And if this works in Karen Reed's case, and boy, Hank Brennan is up against it. He's up against a very defense-friendly judge. He's up against really dishonest, in my opinion, lawyers. And if we get a hung jury or we get a tiny conviction for Karen Reed and an acquittal on the biggest charges, it will be because of two things. One, the judge in this case never put her foot down to the shenanigans, and I think really let them happen in her courtroom. And two, that the O'Keeffes never gave an interview as a family. Look at this piece of media. It's all about Karen Reed.
DNA was found on O'Keeffe's clothing. A key defense witness, Dr. Marie Russell, will be back on the stand for Reed's second trial to testify about O'Keefe's injuries.
They are consistent with a large dog attack. There's a combination of both what I consider bite wounds and scratch wounds.
Another high-profile witness to testify in the trial, Jennifer McCabe. She helped Reed look for O'Keefe.
He said, I hit him, I hit him, I hit him.
A search on McCabe's phone will likely be a focus during Reed's second trial. The state's witnesses and the defense witnesses disagree on the time it happened.
I know.
Can I say one thing just very quickly? Isn't it curious? You really think that all these people are so confused by what they heard? You know, did I hit him? That is quite different than I hit him, I hit him, I hit him. The reason everyone remembers it so clearly is because it was a confession. If she's going through all these different scenarios, did I hit him? Did a plow come and hit him? You notice she never said, did someone beat him up? It was so obvious. Did I hit him in the eye with my, whatever? Was there a hit and run of another car? The only thing anyone remembers from that morning, as far as the first responders, and as far as it not being recorded by the police, I don't believe, if you look at those tapes from that morning, you can only really hear Karen Reed when she's screaming. You can't hear what anyone's saying when they're talking in a normal tone of voice. So I don't find that a convincing argument by Alan Jackson that he made in the first trial, that because it was never recorded any of the times she said, did I hit him? That she said, I hit him, excuse me. Look how effective Karen Reed's campaign is. She has me saying it. Every time she says, I hit him, I hit him, I hit him, it's not recorded.
Never made that search at 2:23. I never would have left John O'Keefe out in the cold to die because he was my friend that I loved.
A love triangle was also on full display between Reed and an ATF agent who was at the party that night.
The defendant kissed me.
And how did she kiss you?
Not like a friend. Defendant responded, you're hot. I responded, are you serious or messing with me?
Those weren't the only embarrassing text messages read to the jury.
Is there an indication that Proctor is going to testify?
Yeah, Proctor's going to testify.
Under you guys or
them? They're going to call him.
From all accounts, he didn't do anything wrong. She's a whack job. No nude so far.
Lead investigator Massachusetts State Trooper Michael Proctor was fired in March after 3 days of trial board hearings. Documents say he was found guilty of unsatisfactory performance and drove his cruiser after drinking at dinner. 2 other state troopers were also disciplined in connection to the case after internal affairs investigations. Sergeant Jeri Buchanan had to forfeit 5 vacation days, while Detective Lieutenant Brian Tully had to give up 6. Reed and her defense have been critical of how the investigation was handled by law enforcement because the homeowner's brother was on the Canton police force.
After 8 a.m., that crime scene was completely open.
Yes.
Unsecured.
Yes.
And available to anybody who wanted access to it.
Correct.
Police say taillight pieces were found outside the Canton home.
So they want police officers to in a nor'easter to round off and stand there and guard it? Rope it off and guard it all night? Is that what they want? I mean, I guess it's the best thing the defense has right now. But I don't think it's gonna. I don't know. I don't know who's going to be on the jury. It depends. If there's a lot of young people on the jury who've been indoctrinated into this mindset that so many innocent people get accused and convicted every day, maybe the Karen Reed will get off. But I mean, her taillight pieces were found embedded in John O'Keefe's shirt. They think that was manipulated. I mean, he was taken out of the crime scene immediately. I mean, they really think that someone's going to plant pieces of taillight there? Really? I can't believe people believe that.
Experts testified DNA belonging to O'Keefe was found on the defendant's taillight, and tiny pieces of plastic were found in his clothing. A federal investigation was launched into how police handled the case, but that's now over.
There is no longer any federal investigation into the investigation of John O'Keefe's death or any related matters. It is closed. It is over.
During that investigation.
Really? When, Tardy? When did, if you're going to say that the police clearly planted the taillight glass, how did they, I mean, first of all, it wasn't glass, it was plastic. But how did they plant pieces of taillight in John O'Keefe's shirt? And they really didn't, I mean, if you watch, they didn't really come close to him. He was out of the scene fairly quickly and onto the ambulance. And the CERT team was there on the scene as Karen Reed's finding pieces of taillight, as Karen Reed's car is being taken to the Sally Port. So the timeline really doesn't support any planning of evidence. There's no opportunity.
The feds hired 2 crash reconstruction experts from ARCA. Both testified during Reed's first trial, but
Wait, what did they say? Did they say the state? Wait. Did I hear right? Hold on, I just have to hear this again.
Both testified during Reed's first.
Wait, let me go back again. Sorry, not far enough.
Matters. It is closed. It is over.
During that investigation, the feds hired 2 crash reconstruction experts from ARCA. Both testified during Reed's first.
So the feds hired them, but are they going to say that the state retained, the defense retained them and paid them and lied to the public and the jury and the court, even after they were found out, and referred to them as neutral, unbiased, unpaid for witnesses? So they got it so much so that they got admonished by the judge for their lack of candor, i.e. lying to the court. Are we going to hear anything about that?
First trial, but prosecutors say the defense misled the court about its relationship with the expert. Reed's attorneys say jurors have come forward saying they agreed to acquit her on the most serious charge, second-degree murder. A gag order is now in effect for attorneys on both sides, with fears the jury...
I get that they have limited time, but come on. That's a really important point. I mean, if I had made this piece, I would have clips of Alan Jackson saying, "You've never met me. You certainly weren't paid. It goes without asking, but you weren't paid. The Commonwealth could have used you." In his direct with Wolf, right? The expert for ARCA on the stand. The Commonwealth could have used you, right? You were not paid. You're unbiased. Some other entity hired you. Just last week, Yannetti was arguing that the federal investigation should come in to show that ARCA are unbiased witnesses. He did that argument with a straight face, and the judge let him. I mean, there's nothing wrong with hiring a defense expert witness, hiring an expert witness if you're a defense team. There would be something wrong if you didn't hire an expert witness in a case like this. However, there is issue when you're not handing over discovery. If the Commonwealth had done anything like this, it's such a massive Brady violation. I think we would have seen, if the Commonwealth had done something like this, we would see a total dismissal of Karen Reed's case. When the defense does it, it's a slap on the wrist. And the defense is misstating things to the court minutes later.
Pool could be tainted.
Through the jury pools, find that there's nobody who hasn't heard of the case, but that you're going to try to do excellent jury selection to at least find people who have an open mind, who are not biased, who are ready to listen to the evidence. That can be tough.
Motions continue to be filed, with the second trial set to begin in April.
It's going to be interesting because we've basically seen a preview because we saw the first trial. This particular trial will have a particularly skilled prosecutor that Hank Brennan is very much admired for his talent as an extremely good attorney. And it's believed that this trial might actually be a little shorter, that it'll be tighter.
Rallies for Reed continue across the country, including here in southern New England.
You see strangers who have come out and supported my sister week in, week out, and now for the first time here in Warwick. It's incredibly uplifting.
You can turn to 10 on air and online for coverage of the second trial. Katie Benoit, NBC 10 News.
Okay. Very much from Karen Reed's point of view. They just skipped over what I think was the most dramatic part of all the pretrial was the arc of revelations, and certainly how I view the case is when things turned from looking like we're going to see an acquittal or seeing another hung jury in this case to some hope for a conviction. Is it enough? Is it too little, too late? In this day and age, will jurors find Karen Reed's own statements along with her car data? So what this means for her car data coming, let's talk about it. Means that they have her GPS now. So every time she opens a door, they'll be able to show exactly what her car was doing, at what time, and where she was located. So, for example, they'll show her at 34 Fairview at close to 12:30 in the morning, going 24 miles an hour in reverse. Her infotainment system beeping and flashing. And I don't know if it will make a record of her hitting something, but then we'll see her, change direct, hit something like John O'Keefe, and change direction and do a 3-point turn and drive away. I don't know. But if there's free Karen Reeders on the jury, I don't think it'll matter. I mean, they could have a video of it. It won't matter. We're going to get another hung jury. That's what I'm worried about. And I'm very curious. I think what I'm most anxious to see is whether this witness harassment campaign will come in, and if not, what questions will be asked of Aidan Carney. Manny, younger people of color will convict her. She's an uppity white woman with money. I read somewhere that they said black women are the most defense-friendly, the women you want on the jury. Younger people of color will convict her. She's an uppity white woman with money. I don't even know if I would be. I don't know. I don't know. I don't know anymore. I don't know if that'll make any difference. She's certainly unlikable, and it was very telling. Let's see. Can I get to that moment? Let me see if I can take a break and see if I can cue up the moment where Alan Jackson asks about the headphones. Hold on.
Karen, just to be clear, you didn't do it.
There is no evidence of any motive, of any intent. Your Honor asks for a proffer from the defense regarding third-party culprit. Alternatively, evidence that would be separate regarding third-party culprit aspect of Bowden. We received some information from the defense that does not distinguish whether their intention is that it applies to third-party culprit or whether it applies to a third-party culprit aspect of Bowden. Those concepts are logically and legally distinct. Regardless, when you look at the proffer by the defense, it is insufficient and inadequate for both third-party culprit and for any third-party culprit aspect of Bowden. Two different analyses, but the evidence is equally feeble for both. Relative to third-party culprit evidence, there are a number of cases that I know Your Honor is aware of that guide the standard of third-party culprit evidence. Not to iterate the law because it is clear, but there must be relevance, there must be a substantial nexus between the claims of the defense and the third-party culprit theory. They provided us 3 people that they identify as third-party culprits. It's helpful just for a quick synopsis of the history. In this case, prior to the first trial, the defense never identified a third-party culprit. At some point, the defendant herself said that they knew who the third-party culprit was, and recently the position of the defense has shifted that they don't know and don't need to know. Now, the law accommodates specifically identifying somebody. It also accommodates general, but it has to have specificity in the complaint. There has to be a motive, an opportunity, and an intention. There has to be evidence that draws the correlation. It can't be bad character, speculative, or just putting out information that's negative towards a witness so that that can backdoor prior bad acts against a witness and be used for a different purpose. They identified one person, Colin Albert, and in their proffer, what they offer, number one, and it's important to take them separately because it shows how feeble it actually is. The first thing they say about Colin Albert is he had a feud with John O'Keefe in the weeks and months leading up to January 29, 2022. Now, other than maybe on social media or in interviews with the defendant in national broadcasts, there's no evidence of that. There is no evidence that's going to be admitted at this trial that shows there was a feud between Colin Albert and John O'Keefe. There is no evidence that there was any hostility between Colin Albert and John O'Keefe. There's no evidence of a motive to kill John O'Keefe by Colin Albert. There is no evidence of any motive, of any intention, or of any opportunity whatsoever. In fact, the evidence is that Colin Albert was not even at 34 Fairview at the time John O'Keefe arrived there on January 29, 2022. And so simply saying it is not evidence. And an attorney should not be allowed to confront a witness about an allegation that has no factual basis for them to then have to defend the accusation. The prejudice then seeps to the jury, and the Commonwealth is in the position of having to disprove a claim. That had no basis to begin with. The second claim that they make regarding Colin Albert is that he had thrown beer cans in Mr. O'Keefe's bushes and told Mr. O'Keefe to F off in his face. There is no basis for those claims. There is no witness for those claims. There's no information regarding those claims. I understand there may have been a party where there was beer cans, but there was no Colin Albert. So to attribute a situation or an incident to him, the defense would need some good faith proof, actual proof, fact, that this actually happened. And there's no evidence whatsoever that Colin Albert threw beer cans in Mr. O'Keefe's bushes and told him to F off. And the reason there's no proof is because it didn't happen.
The reason there's no proof is because it didn't happen. Can everybody hear me okay? I see some people in the chat saying they can't hear me. Can you hear me now? It's just so outrageous. How dare you think that we need proof for anything that we're saying? We've gone this far. We've gone this far with no proof.
So again, the defense asks for an invitation to simply cross-examine a witness, allege a prior bad act, and then the witness has to defend their honor and the government has to disprove it. That is not the cloth that third-party culprit is made from. Regarding the suggestion that there was some type of feud or tough relationship, I saw on a video that there were two radio personalities, and I have the clip, who spoke and met with Karen Reed, and during the conversations, at least they relayed that there was some claims about a drug issue, and according not to the defendant, but according to the interviewers who supposedly interviewed her, they said that the story is completely false. They attribute this to Karen Reed. People are trying to make it more dramatic, like Colin would have a reason to hate John O'Keefe. That never happened, referring to some drug claim. He did not report him for anything. And so what we know is there is no history of animosity between Colin and Albert.
That drug claim was started as a way to troll Turtle Boy by Kate Peter. She started that rumor herself. It's my understanding. This shows you how now it's coming into court, how dangerous it is when you play games like that, like starting a rumor because you want Turtle Boy to look stupid, and then now the Commonwealth is debunking a substance problem rumor and a substance dealing rumor.
And John O'Keefe. We know that there was no animosity between his family and John O'Keefe. The only event known is that at some point, Colin Albert's younger brother ran across John's lawn. Mr. O'Keefe supposedly yelled at him and then bought him candy as an apology. That's it. So we have an alleged third-party culprit, a very strong claim, with no evidence, no motive, no opportunity, not even present at the time that this alleged collision occurred. And so in that absence of evidence, it's not even feasible. Colin Albert should not be brought to the stand, attacked with acts that didn't occur, that otherwise would have no admissibility. Really, it seemed to be a backdoor way to tarnish his reputation and then bind him with other people the defense would like to attack, to make a general suggestion that somehow this group of people are bad people. I know at the last trial, there was pictures of Colin Albert's knuckles that were scraped, and inevitably it turns out that picture, I think the exhibits were introduced at trial, was taken much later. Pictures taken before that point show that Colin Albert's knuckles on the 9th and 11th of February weren't scraped at all. So because he had scraped knuckles, subsequently, because he may have done a video that some youths would maybe do and threaten somebody else, not John O'Keefe, has nothing to do with this case whatsoever. It's an attempt to introduce alleged aggression or prior bad acts, but there's no...
Right, there's no bad acts there. I believe that this is Colin Albert. He was calling out a rival sports team. I mean, it's so absurd. And it came off, when I was watching the ID Discovery TV show, their edit of the trial was so different than my memory of that trial. And it made the defense look like superstars, and that no reasonable person would ever want to convict Karen Read of anything. It shows you how powerful editing is. They took a almost 10-week trial and riddled it down to, an episode and a half, missing tons of witnesses and showing the worst parts of some of the Commonwealth's important witnesses. I mean, Buchanan didn't even show up in it. It just looked like you would think if you only watch the ID Discovery, you would think that the only police officer involved was very nervous Trooper Paul and Trooper Proctor.
Bind whatsoever. The second person that the defense would like to identify as a third-party culprit is Brian Albert. And this is some of the gross generalizations that you see with Colin Albert. No specificity, but trying to assault his general character by generally suggesting things that may or may not be accurate in just telling part of the story. They claim he didn't have a good reputation among fellow police officers. No evidence. They claim it. And even if it was so, has nothing to do with this case. Known as a bully. So rumor clearly is not admissible in a criminal case. Had a history of sucker punching officers. We don't see any specificity. We don't see any evidence. We don't see any information. We just see a general attempt at a character assassination to portray him as somebody who is either capable or a bully. Nothing relative to John O'Keefe. Nothing. They suggest, and I'm not sure what the basis for this is, that he was drinking heavily that day when he went to a funeral with Mr. Higgins and another person. It is true that he was at the hillside around 9 o'clock and was drinking around 9 o'clock. So all of this information is just general inflammatory accusations about character. They say he was a trained boxer because when he worked out, he boxed and he was engaged in charity events, some dating back to 2003. By that standard, anybody in the neighborhood who has any self-defense training, mixed martial arts, or boxer would be on the target list. The fact that he is a police officer and that he is physically fit and that he trained to protect himself doesn't make him a third-party culprit. It is this general suggestion of strength and distorted into a hopefully perceived sense of violence that it has no root at all.
So, I mean, I think the judge is still going to allow a third-party culprit. And so my view is that even with this excellent argument by Hank Brennan, who teaches law, who's worked in federal court, civil court, criminal court, that Judge Cannone is still going to allow it, and she's going to allow the defense to develop it. But by allowing them to do what she did last time, this is what she did last time. She allowed the defense to develop it, and then Yannetti opened on it. There was no developing of a third-party culprit. And on opening, Yannetti said, my client's been framed, and he hinted at all these other people who could have done it, with no development in cross-examination. And of course, nothing happened. So if Cannone does a ruling like that, that's what it means. It means that they're going to open on it, and they may not be as direct as naming the people, but they'll hint around it, and they'll put Colin Albert and Jen McCabe, etc. Also, this time around, there's Higgins is now the new. Higgins has replaced Jennifer McCabe as having motive. I think Hank Brennan refers to it. Also, there was a ruling, sort of buried the lead here. Stay with me. Is everyone still with me? Hope so. There's a ruling by Judge Cannone. She denied Karen Reed's motion to dismiss. She also, so this has just been unsealed, she also included a transcript with a dismissed juror. So do you remember that juror that got dismissed? And the rumor was that this juror was at a bar bragging about being a turtle rider, getting on the jury. So this is how it went. So here's the transcript of the conversation with the jury. So the court, meaning Judge Cannone, it's been brought to my attention that you might have been out recently at an American Legion or a Knights of Columbus or someplace like that. So a police officer overheard it, and I believe recorded it, or someplace like that in Denham, and that someone has reported that you may have been recorded talking about this case. That's the information I received. What can you tell me about any of that? The juror, this is like, thank heavens this juror got thrown off. The juror, I don't know. It's like practically taking the fifth as juror. The court, have you been at an American Legion Hall? The juror, like a month ago. The court, okay, at the time, were you at all talking about? The juror, not that I remember, no. Doesn't even wait for Judge Cannone to describe exactly what she said. She doesn't remember what she hasn't heard about the case. I mean, wouldn't you, if you didn't say it, wouldn't you be dying to know what someone said? Give me an idea. What did someone say? What were they talking about? The court, do you remember if people there mentioned to you anything about this case? The juror, I was drinking. I don't remember. Doing a straight up Karen Reed. Karen Reed likes to do this. I don't remember. I have a bad memory when I'm drinking, but I remember everything. The court, okay. The further information I have is that this morning, several Denton police officers, several, not just one, several Denton police officers said that they heard the same thing. Okay. All right. Could it have happened? The juror, I don't know. The court, okay. The juror, I really don't know. What a liar. How did that woman get on the jury? This is what I worry about. Tomorrow I'm going to talk about Bradle, Aiden Turney. I had a whole bunch of it prepared for today, but I think I'm going to save it for tomorrow. But so a bad ruling for Karen Reed, or that looks like so many of her own statements are coming in, but not her statements with Yannetti. To no one's surprise. And let's see which way the judge goes on this third-party culprit. I mean, I'd be curious to, let's just finish up here. I'd be curious to know what you all think. Let me do a poll. Will Judge Cannone allow the defense to argue third, the other recent party culprit? Frankly, I think it would be oh, wait, hold on one second. I think it would actually be a blessing for the defense, because I thought it made them look sleazy and untrustworthy, them sort of just going around saying they were framed. I think it's much better to say it's a poor investigation than say it was a 50-person conspiracy of which we have no evidence. Okay, I'm going to try again. I was creating a Q&A, not a poll. Will Judge Cannone allow the defense to use a third-party culprit? Defense curious. I'm just going to say yes, no. So fence sitters, sit this one out. If you don't know, just sit it out. I'm not going to have an out on this poll. No easy out. Like, I don't know. Is everybody still with me?
No room. They went as far to say he was investigated by BPD for violent conduct, but they don't give any details. If they looked, they could go online, they could investigate potentially. There is no sustained findings that are known to the Commonwealth against Brian Albert in internal affairs, none whatsoever, ever. And so to make the suggestion he was investigated by BPD for violent conduct, they provide no fact. I'll say, even though it is off base entirely, it has nothing to do with John O'Keefe. They're trying to suggest that he has a propensity for violence. And they don't do it very well because they provide no details. These are all just general accusations by the defense. In fact, I would say it's not important or admissible. You can't bolster the good character of a witness, but to simply make suggestions of bad character is not any root or tethering to this case specifically. Instead of bad character, Brian Albert was a two-time recipient of the George Hanna Award, has many, many medals of honor from the Boston Police Department, but that is not the issue. They suggest that he was involved, so they know that they have to tie him not only to the scene, but somehow to Mr. O'Keefe. And other than being at the bar that night and Mr. O'Keefe and Miss Reed pulling in front of his property that night, there is.
That was interesting. Speaking of his property, that was a fascinating piece in the ID discovery where they mentioned there were railroad tracks behind 34 Fairview. So believe it was Brendan Kane, may have been John Jackson, who's friends with John O'Keefe, who said, why are they putting the seasoned police officer who Hank Brennan just remarked has won all these awards? You can see Brian Albert escort, these high profile catches, I think they're the accused at that point, defendants that become defendants and ultimately become the convicted. Like Clark Rockefeller, the man who Gerheiser, who pretended to be a Rockefeller. You can see Brian Albert have him arrested, escorting him in cuffs. And why put him in the front lawn? Why put John O'Keefe in the front lawn if you're such a seasoned police officer? Why not the back of the house that has railroad tracks? Why anywhere else but the front of your lawn? Why not just put signs and balloons, speaking of balloons again, saying, he's here. We did it. What were they planning on doing? Just letting him rot in the front yard? What do they have plans? I mean, isn't it so insulting? Aren't the Free Karen readers insulted that this isn't a better story? It's not consistent. It has no beginning, middle, and end that makes any sense. Not one Free Karen reader can tell this made up defense narrative from beginning to end in a way that makes sense, that incorporates the evidence. They can only tell it in little pieces with little pieces of evidence. See, it looks like dog bites. A lot of things look like other things. A watermelon and a basketball look slightly alike. An apple and an orange. A piece of plastic fruit and a real piece of fruit look a lot alike, but aren't. And certainly I who have been bitten by a dog very seriously when I was little, so much so that the ER wouldn't take me. My mother had to take me to a plastic surgeon when I was 5 years old, around then. And I had to wait 8 hours as a woman had a facelift for the plastic surgeon to become available to sew back my face together. I can tell you this does not look like a dog bite. But I would be so angry if I were a Free Karen reader that they can't tell me a consistent story from beginning to end. And it changes all the time, and not one eyebrow raised from Free Karen read. It is the essence of their defense is, why come? Why come it looks like dog bites? Why come there's so many butt dials? Huh? Tell me that. Why come solo cups? Why come? Why come? Nobody's asking why come Karen Reed reversed 24 miles an hour in reverse with her infotainment system beeping and flashing at her. Why come Karen Reed's pieces of Karen Reed's taillight were embedded in John O'Keefe's shirt? Why come the defense won't hand over discovery to the Commonwealth? Why come the defense lied continually to the public, the jury, and the court continuously about the ARCA witnesses, that they were unbiased, unpaid for, unretained witnesses. What is happening with the discovery? It's hard to know. I assume Hank Brennan's gotten discovery, but it certainly was vague at the end of this hearing. And he's going to work it out with Robert Alessi about ARCA. He said, oh no, they were going to work out the Commonwealths. Excuse me. I misspoke. You lie. I lie. They were going to work out the Commonwealth has a big board of all the car data for the jury. Thanks, Manny. Yeah, but they've hid discovery in to the last minute in the first trial, so much so that we had 2 voir dires, and in this trial, it's only after they got admonished by the court and dragged over coals did they hand over discovery at the last minute. I assume it's handed over. Assume we would hear about it if it wasn't handed over.
No association between the two. They say he's present at the scene of death. By all evidence.
All right, that may be the sign that I've stayed too long. How long have we gone at 1:45? But let me just try to finish up with Hank Brennan. I just feel like we're incomplete here with his argument over discovery. If I can find where I was, hold on. This is, I'm going to see where we are with our poll in a second.
Here's a big question.
Okay.
Predicate rely on innuendo, surmise, speculation, or just the creation of an inference that does not exist. There is no evidence Brian Albert had any motive whatsoever to harm John O'Keefe. None. There's not one witness, there's not one statement that Brian Albert had any animus whatsoever towards John O'Keefe. None. He did not have the motive. He did not have the opportunity. And there is no evidence that he was involved in any way in the alleged collision that happened in the front of his yard that night. Finally, the defense turned to Mr. Higgins. Mr. Higgins was at the Albert address that night. John O'Keefe never went into the Albert address that night. They take very, very select pieces of information, and I would suggest don't tell the whole story. And from that, they want us to speculate a motive. For example, they say that Karen Reed had kissed Mr. Higgins at John's house. That seems to be corroborated in the text messages. According to the text messages, Mr. Higgins essentially says that Miss Reed came up to him and planted a kiss on him. And there's quite a bit of text message exchange that you heard during trial about that interaction. And then at some point, Miss Reed looked at Mr. Higgins' house. And so there was some interest that would appear from the text messages between the two. Mutual, at best. There's a plethora of text messages where Miss Reed is pursuing Mr. Higgins, looking for his time, looking for his intention. In one, she says, of basically begging him to come over. Do you like me? Come over to my house.
So this goes without saying. I don't know who thought that this motion was going to go anywhere, but Judge Cannone denied Karen Reed's motion for extraordinary government misconduct. I mean, anybody surprised by that? Anybody surprised by that? Just a reminder. It was a Hail Mary, and it got no, a big NO. Okay. Where are we on our poll? 66. So a little bit uncertain. You know, the people who are saying that she's going to let it in have a point. Because the idea behind a retrial is to streamline it.
There are text messages talking about Mr. Higgins not having enough time for her. So there is a flirtatious relationship between the two of them. What we don't see is that somehow that creates a motive for Mr. Higgins to want to hurt or kill John O'Keefe. The fact that they are texting together and later that night he sends a text message because I think an inference the defense would raise is that he felt like he was ignored or wanted to know what was going on with their relationship, is not evidence of motive. In all of these text messages, you never see any animosity towards John O'Keefe. Mr. Higgins's text messages are virtually all kind towards John O'Keefe. It's uncomfortable. It's an awkward situation because both of them appear to be deceptive as it relates to John O'Keefe, but there is no vengeance, there is no anger. And so the suggestion...
Right. And if he really had anger, he would have jumped into bed with Karen Reed immediately if he really hated John O'Keefe. He was that jealous. Instead, he's like, oh, what now? And as for Brian Higgins destroying his phone, I think he'd been around a lot of criminally minded people like Karen Reed. And if you know anything about Karen Reed, she searches Facebook like no other, is always looking for private information. Anna Shaw, I have something to talk about Carl in a minute. Yeah, I can't believe him either. But I get asked about Carl Steinbeck more almost every show. So I'm going to address it in a second. But I would throw my phone into a volcano, having done nothing, having never known John O'Keefe, never coming in the area of 34 Fairview on January 28, 2022. I would still throw my phone into, if I knew I were being called as a witness in this case. After it was cleared, he was cleared to get rid of his phone and he got rid of it. After they extracted data, hardly incriminating.
That there is a motive because there was flirtatious text messages to then kill the man is beyond the pale. It's beyond any logical connection that would support third-party culprit. Brian Higgins sent a text message saying to John O'Keefe, asking if he was coming to the home that night, and they then attached the word he lured them to the house. I mean, we do look at this evidence not in a vacuum, but logically and realistically. Not knowing that Karen Reed was not going to come in when they arrived at the house, is it reasonable, is it rational, is it lucid to think that that Mr. Higgins was inviting them both over to the house, not knowing only one of them would get out of the car? Is the suggestion that Mr. Higgins was going to kill both of them? Or he was going to kill one of them, so the other one he would then set up for murder so that he wouldn't be able to see her anyways? The absurdity of the relationship between the claim and reality is so great that it will just run rampant through this trial. It will be unrelated, speculative, shotgun approach to claims that the witness will spend their time trying to explain and defend it will distract the jury, and it will serve the purpose, which the case law says it shouldn't, of taking attention off the facts at issue for the case we're here from. And that attempt to divert anybody but the defendant is the attempt here. That's why we have three, we don't know who, but three potential third-party culprit evidences with absolutely fragile evidence. It's feeble. As their support, what they offer is they believe Mr. Higgins lied because he went to the Canton Police Department to do administrative work. And I think the evidence is clear that he had cars that he parked there as part of his job that he needed to clean off. So
Right. I mean, do this thing like Brian Higgins was on the phone. He's moving cars. He was talking on the phone. He had his phone up to his face. You don't know if he was listening to messages. You don't know what he was doing with his phone. Thank you, Anna Shaw, for the super sticker. But they make, as the defense always does, makes big leaps in logic. From having a phone up to your ear, he's moving cars before a giant nor'easter, to, oh, he's doing something nefarious after he murdered John O'Keefe and planted Karen Reed's taillight, embedded it in his shirt and all over the scene because no one likes the finance professor.
they are parsing words in an attempt to create a basis that doesn't exist. That there are calls between Mr. Albert and Mr. Higgins later that night. So what? They have no evidence that either of them spoke to each other. They have no evidence of conversations. They have no evidence of a conspiracy. They have no evidence of a cover-up. They have no evidence of a weapon. What we know is John O'Keefe never went in the home. And so to try to create this image based on obscure facts is not the substance that's required under third-party culprit. I know third-party culprit is a time-honored tradition and is a broad latitude, but it's not endless. It can't prejudice the Commonwealth. It can't distract the jury. It can't be based on fiction. It has to be based on an identifiable theory. The cases that have allowed third-party culprit that have been...
It's amazing that she let this in the first time, considering that those are the qualifications. It has to be based in reality. You can't just assume that everyone who was there has a motive, and there has to be some evidence of it. So I think that's a good place to leave it as far as Hank Brennan. As for Carl Steinbeck, so just to go back to my history with Carl Steinbeck, he is a lawyer. My understanding is he was a lawyer and the military lawyer, and he's always looking for consulting work. He makes monetized videos on cases, and we shared a case in the murder of Dan Markel. We were both talking about that case at the same time, and we had what was a friendly relationship. He said some nice things about me. I appreciated that. My channel. Then, all out of the blue, and he would end every show saying, you know, justice for Dan Markel. And I would begin every show, justice for Dan Markel. And I'm so glad that you're listening, you say to his audience, and are interested in getting justice for Dan Markel. So that's how he presented his motive for talking about the Markel case. And he would turn down super chats. Even though his videos were monetized. Which never really made sense to me. You know, either turn it all off or accept super chats, because it's essentially you're making money off the views of it anyway, but okay. And then so out of the blue, he said he was supporting Karen. He described the Karen Reed case, not knowing much about the case, not knowing the details of the case, threw his weight behind Karen Reed without educating himself about the case. He admitted that many times. My memory of it is many times in a live. And I was in the chat and asked him, why do the Markell family deserve justice and not the O'Keefes? I was thrown out of the chat, as were many like-minded people. And I believe what I've heard, I've never gone back and listened to it. What I've heard is that he made a speech about me questioning his integrity. He has since doubled down on his ignorant opinion and become a real life murderer groupie, in my opinion, and continuing to put out these false narratives without really ever checking out the other side. So I left him. I'm asked about this almost every single live stream. I get a message about Carl. Why is he doing this? And only Carl can answer why he's doing this. I'm not going to speculate anymore about it. But I wrote, hey, Carl, the fact that you started supporting an accused cop killer who spearheaded a witness victim's family harassment campaign and her fraud team of lawyers before you, quote, knew much about the case, unquote, says more about your moral depravity and lack of character than I ever could. Enjoy the blood money you receive re-victimizing the O'Keefe family. So that's the last thing I'm going to say about that, hopefully. But disgust is too weak a word for how I feel about that. I will see you guys tomorrow at 6. Hopefully we'll get into Bradle a little bit. There's a lot of disinformation going around about him. I think I might surprise you all where I land on that. Aidan Carney's attorney is being accused of and actually going up in front of a board for his behavior in a wrongful conviction case. Might surprise you all where I land on that. And we're going to, of course, talk probably more about Karen Reed. Have a great night, everyone. See you tomorrow.
I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mom. My innocence fraud campaign is my biggest hit yet. I hit my boyfriend with my car. It wasn't an accident, but with lying lawyers I'll go far. Lying lawyers and witness harassment, I'll avoid prison. It was snowing. I pushed the pedal down, hit him hard. Now the legal system a clown. Innocence fraud campaign to save my skin. Making money, truth is my second victim. Carry, Jen, like John, you were my mark. My innocence fraud campaign is my biggest stick, yeah. I just